It's finally over. An appeals court confirmed that Google's scanning of more than 20 million books counts as fair use. It has been 10 years since authors first sued Google -0.01% over the decision to scan millions of books, but now an appeals court appears to have confirmed once and for all the scanning did not violate copyright law. In a unanimous ruling handed down on Friday morning, the Second Circuit Court of Appeals in New York deployed a familiar four-factor fair use test to conclude that the Google Books project was lawful. We see no reason in this case why Google's overall profit motivation should prevail as a reason for denying fair use over its highly convincing transformative purpose, together with the absence of significant substitutive competition, as reasons for granting fair use, wrote Justice Pierre Laval. This ruling appears to settle once and for all a case that began in 2005 when the Authors Guild as well as a number of book publishers brought lawsuits against Google over a project that saw the company partner with dozens of libraries to scan over 20 million books. Today's decision underlines what people who use the service tell us: Google Books gives them a useful and easy way to find books they want to read and buy, while at the same time benefiting copyright holders. We were pleased the court has confirmed that the project is fair use, acting like a card catalog for the digital age, said a Google spokesperson. While the parties initially reached a settlement that would have created a revenue-sharing model based on the scan collection, a judge rejected the deal in 2011, saying it was a bridge too far. In response, the Authors Guild renewed its lawsuit shortly after, but suffered a major setback in 2013 when a judge first ruled the scanning was fair use. Friday's appeals court ruling is significant because it clears the legal uncertainty that has been hanging over Google for a decade, and also because it provides more guidance on what qualifies as fair use in a digital age. In particular, the court states on several occasions how copyright law represents a balance between authors and the public, and points out how many forms of fair use are partly commercial. Many of the most universally accepted forms of fair use, such as news reporting and commentary, quotation in historical or analytic books, reviews of books, and performances, as well as parody, are all normally done commercially for profit. The Authors Guild did not immediately respond to a request for comment. This story will be updated shortly with more details. Here is a copy of the ruling with some of the relevant parts underlined.